Welcome. Today's video covers public filming, the overbreadth doctrine, and injunctive relief, and comes from Long Island Audit's channel. A link to the original video can be found in the description below. On August 9, 2021, Long Island Audit began filming in the parking lot of the Larchmont Village Hall in Larchmont, New York, when officers of the Larchmont Police Department, who clearly do very well in serving their community, approached him.
No, I don't need any help. Can I get your name and badge number, though?
No, you cannot. Can I help you?
I can't get your name and badge number, ma'am?
What are you doing in the back parking lot?
I'm an independent journalist gathering content for a story, ma'am.
Okay, about what?
I don't want to release that information until it's published.
Okay, well, there's no reason for you to be in the back lot. It's police department and employees only.
Ma'am, that's not true. There is.
This is police parking.
Can I show you the signs?
And village parking only.
Yeah.
Yes, it's village employee parking only.
Yeah. I'm not parking, ma'am. I'm walking.
Village employees only.
Ma'am, I would ask that you use a little bit of de-escalation.
Okay, well, I'm gonna
Because you came in kind of hot. You came in kind of hot.
I'm going to ask you to
This
leave
is
the back lot.
This is public property.
No, it is not public property. This is private property. There are police vehicles back here.
That doesn't make that. What law is that? What law means?
It's a village code. It is private property.
Can you articulate that code for me?
Here. Off the top of my head, no. I can go inside and get it.
Can you stop covering your name and badge number? Can I get you? How am I supposed to respect your authority if I don't know who you are?
The officer claims that the parking lot is private property because a municipal ordinance says so, even though she cannot cite this code. In general, all government property, including buildings and parking lots, are public property because they are purchased and maintained with public funds and managed by government officials who are ultimately supposed to be acting as servants on behalf of the people. Consequently, it is incorrect to classify the parking lot as private property because it is designated for governmental purposes.
Can I get your name and badge number, sir?
My name is Goord, badge number 227.
Thank you. I appreciate that. Thank you. Thank you for identifying yourself as a law enforcement officer. I appreciate that.
He told me he's doing a report.
How you doing today, sir?
Good, what's up, man?
Can I get your name and badge number, please?
Sure,
Irvine?
16.
16?
216.
216. Thank you. Nice to meet you. Yeah.
Court clerk and apply for a filming permit.
Pompilio.
Pompilio Shield 28. I'm Sergeant.
Thank you for identifying
So
yourself.
you need to go upstairs
Appreciate
to
that.
the second floor to the clerk's office.
Yeah.
And apply for a permit to film.
Why would I? It's freedom. I have freedom of the press.
It is not freedom of press. This is private property.
The officer states that filming is not protected by the First Amendment and that any filming on any government property requires a permit pursuant to a municipal code. In the cases of Glick versus Cuniff, Fields versus Philadelphia, Turner versus Driver, ACLU versus Alvarez, Fordyce versus Seattle, Animal Legal Defense Fund versus Waston, Irizarry versus Yehia, Smith versus Cummings, Toole versus City of Atlanta, and many, many others, the United States Courts of Appeal for the 1st, 3rd, 5th, 7th, 9th, 10th, and 11th Circuits all held that the act of taking photographs and videos in public is protected by the First Amendment. Additionally, in the case of Silberberg v. Board of Elections of New York, Judge Kevin Castell of the United States District Court for the Southern District of New York, which has jurisdiction over Larchmont, said, it follows that the taking of photographs is also protected by the First Amendment. While the Second Circuit Court of Appeals, which has jurisdiction over New York, has not explicitly held that the First Amendment protects the right to film in public, the fact that nearly two-thirds of the country in countless federal and state judicial rulings have determined that such a right exists makes this officer's claim to the contrary ridiculous, and a court could easily conclude that, even without an opinion from the Second Circuit or the New York Court of Appeals, the right has been clearly established. This does not, however, mean that the auditor has the right to film whenever and wherever he pleases. As stated multiple times on this channel and in the case of Adderley versus Florida, the state, no less than a private owner of property, has power to preserve the property under its control for the use to which it is lawfully dedicated. Since quintessential public forums, such as sidewalks, streets, and parks, have historically been dedicated to indiscriminate public use and discourse, the ability of the government to restrict speech is sharply circumscribed. But when property is erected by the government with a dedicated purpose other than speech, it is considered a non-public forum, and speech-related activity, including filming, can be restricted so long as the restriction is reasonable in light of the purpose of the forum and is viewpoint neutral. Judge Castell said in his opinion above, the City Board's no photography policy does not contravene the First Amendment, polling sites are non-public fora and the policy is a reasonable, viewpoint-neutral restriction to maintain order at polling sites and decrease wait times. Since the parking area is designated for the purpose of parking vehicles and filming has no relation to that purpose, a court could find that, if a First Amendment right to film does exist, it was not implicated by a neutral and generally applicable law prohibiting the activity on that specific property.
Fenced off.
This is not fenced off.
It says authorized personnel only.
No, that's, you just,
If you are filming on village property.
you literally just lied.
Excuse me, I'm not lying.
That's not what that sign says.
It's fenced off, correct? Do you see the fence back
There is no fence here, ma'am.
There doesn't need to be a fence here in the event we have to get out in an emergency. It is fenced off on the perimeter.
Yeah.
If you are filming on village property,
Yeah.
you must get a permit for videoing.
What law is that?
That's a village code.
Okay, calm
So
down.
you can go upstairs to the second floor.
Yeah.
And you could apply for a permit to be videotaping on village property.
The First Amendment gives me the right to film in public.
Not on village property. It is a village code.
Village
of Larchmont code.
If you're going to be enforcing code on me, I would like to know the code,
You
please.
Go upstairs and speak to the clerk.
But you're telling me that
I'm telling you
Yeah.
that you have to have a permit
Yeah.
to videotape in the village
according
of
to a
Larchmont.
according to a
the
law.
Village of Larchmont code. It's
Code.
not a law. It is a code.
Okay, and you cannot articulate what code that
You have
is.
to go upstairs and get it.
Okay, so are you giving me a lawful order to leave?
Yes, I'm telling you, you cannot videotape on village property without a permit. Even if you were making a commercial or you're filming a movie, any videotaping in the village of Larchmont, you must apply for a permit.
The officer claims a municipal code, which is a local law contrary to her assertion otherwise, prohibits the act of filming on the property without a permit. Section 157-2 of the Larchmont Municipal Code says, no person shall film on any public or private property in the village of Larchmont without first making an application to and obtaining a permit from the village administrator for the filming. Filming is defined in Section 157-1 as the taking of still or motion pictures, either on film or videotape or similar recording medium, for commercial or educational purposes intended for viewing on the Internet, and public property includes every public street, highway, sidewalk, square, public park or playground, or any other public place within the village which is within the jurisdiction and control of the village of Larchmont. Based on the language of the ordinance, any person who intends to film anything anywhere for any educational purpose must first receive permission from the government to do so. There are serious constitutional concerns with this. While the ordinance would likely be constitutional as applied to this auditor in this specific circumstance because there is likely no right to film on this property, its blanket prohibition sweeps beyond non-public forums and applies to all places where a right to film would exist. Because of how much protected speech it implicates, it could likely be challenged as overbroad. When a plaintiff challenges an ordinance as being overbroad, he is alleging that it burdens so much protected speech that it would be unconstitutional in such a significant number of cases that it will consistently compromise the rights of others. In City Council versus Taxpayers for Vincent, the Supreme Court said, in order to decide whether the overbreadth exception is applicable in a particular case, we have weighed the likelihood that the statute's very existence will inhibit free expression, and there must be a realistic danger that the statute itself, rather than its application in a few circumstances, will significantly compromise recognized First Amendment protections of parties not before the court for it to be facially challenged on overbreadth grounds. As a result, the law is unconstitutionally overbroad only if it reaches substantially beyond the permissible scope of legislative regulation. If an overbreadth challenge succeeds, the plaintiff cannot be held liable for violating the ordinance, even if the ordinance would have been constitutional as applied to him. Here, because the Larchmont Ordinance appears to go significantly beyond the permissible scope of legislation and burden a vast amount of protected speech, a court could easily conclude that it is overbroad and thus cannot be applied to anyone, including the auditor.
On public property.
On public property.
Okay.
This is public property. It belongs to the village of Larchmont.
Yeah.
There are police vehicles and other things that are not accessible to the public here on this property. In order to videotape anything on Larchmont village property, anywhere in the village of Larchmont, you must apply for a permit.
Where are you getting that? Where are you getting that information from, Sergeant?
Our code, our village code.
The one you don't know.
Give me a second and I will get it for you.
Thank you.
Subdivision 2, no filming shall be conducted on public property without prior approval of the Village of Larchmont Board of Trustees. So you cannot film on our property without prior approval.
That's interesting, because it's public property, but that's interesting. I mean, I'm not doubting your code that you're reading.
Public property within the Village of Larchmont, you must obtain prior approval by the Village of Larchmont Board of Trustees.
That code is completely unconstitutional.
It is not unconstitutional. It is a village code. Village boards are allowed to constitute their own codes.
Ma'am, freedom of press means that there's no restrictions on it.
To the court clerk's office.
I will be going up there. I will be going up there.
Do that now.
I will be going up there. I will. This is definitely not your property. This is a public easement.
You can go upstairs and apply for a permit to videotape.
Yeah. So I just want to clarify. So anywhere I go in this city, I have to have a permit to film. Just for clarification.
You must have a permit.
Yeah.
Whether you are on public property or private property within the Village of Larchmont.
Okay.
It's
So
our
even from what I have the right to film the police from New York State law.
You are not allowed in the back parking lot on public property
Mm-hmm.
to film without prior approval by the Board of Trustees.
Okay.
If you are filming commercial in your private residence, you must apply for a permit.
That's interesting. That's in direct violation of the Constitution.
It is the village code. The village is allowed to have their own code. If you have an issue,
They can-
you can take it up with the village.
I will. No,
code.
they can have their own code, but they can't have a code that violates the Constitution that you took an oath to, man.
I'm not answering any
I'm
more
gonna ask you anyway.
questions.
What happens when you violate a code? What are the repercussions for violating Larchmont Village? Yes,
It is actually an arrest.
it's an arrestable offense.
You get a DAT and you have to appear in court on the.
Can you give me one of? Can you give me one of those?
I'm not giving you an arrest ticket right now. No.
But I'm not.
Giving you a warning to go see the court clerk.
I would like an arrest ticket.
We don't give them out when people ask for them.
So I'm continuing to film. I'm breaking the code. So if you're saying that I can't film. I'm on a public sidewalk. Let me make that very clear. I'm on a public sidewalk, and if it's against the code for me to film,
You are filming into the back lot where there is police
so
apparatus.
so,
I've
ma'am.
asked you multiple times to go see.
I understand that, ma'am. So I would invite you to write me up on the code, ma'am. I would invite you to do that because it's unconstitutional. It's unconstitutional, ma'am. It's unconstitutional, and I would invite you to write me up on it.
Village property.
I am not. I am not. I am not even on village property anymore.
Well, the sidewalk technically belongs to the village.
It technically belongs to the people, ma'am.
It doesn't belong to the people. It belongs to
Ma'am,
the village of
I'm gonna try and be reasonable here. It's not against you, it's against that code, and I'm gonna continue to film what I could see from public.
Stop videotaping into the police lot.
Ma'am, I'm not gonna stop doing that because this is unconstitutional.
I'm going to ask you to go see the village clerk to obtain a permit to continue videotaping.
Ma'am, I'm going to stick up for what I believe in here. I believe in the Constitution. I believe in freedom of press. So if you need to write me, if you need me, if you would like to, you can arrest me or write your ticket of arrest, whatever that is. I invite you to do that. Whatever you need to do. I'm not moving from here, ma'am. I'm not moving from here. Yeah, sure.
Do you plan on ever getting permits?
No,
Just wondering.
no. I'm not going to get a permit to film in public. No,
Just asking.
no.
Does anyone else? Is this similar to anything else, like any other village codes?
No. I've never run across a village code that is in direct a violation of the Constitution like this.
Is that like for state parks? When they have, when I used to work there, they had.
State
this
where?
was for commercial activities. This
Yeah.
is considered commercial.
Yeah.
Right. So
Uh-huh.
I was wondering.
What do you said state what?
Like when I worked at the state parks, commercial
Okay.
activity was required. I'm not saying.
Yeah.
I'm just wondering.
No. Yeah, probably they could regulate commercial, like if I was shooting a movie or something like that. Yeah. If you're shooting, if you're shooting like a movie or something, but I'm an investigative journalist,
Right.
so that's freedom. That falls under freedom of the press, which can't be violated in any way. So that's why I'm inviting your sergeant. She read me her code, and I understand that, but I'm inviting her to arrest me on that code, so that way, because when she does, I can then take it to court and get that code changed.
The auditor is not actually required to face a penalty in order to challenge the constitutionality of the ordinance. A person can challenge the constitutionality of an ordinance if he could probably face retaliation for protected conduct that he intends to engage in. In these cases, the plaintiff files for what is known as injunctive relief, where a court will issue an order against the government restraining them from enforcing a certain law, whether for a portion of time or permanently. In Woods v. Goord, the United States District Court for the Southern District of New York explained, in order to obtain an injunction, a plaintiff must ordinarily demonstrate the possibility of irreparable harm and either a likelihood of success on the merits or sufficiently serious questions going to the merits, such that a fair ground for litigation has been demonstrated, and a balance of hardships tipping decidedly toward the party seeking relief. The evidence is clear that this law is unconstitutionally overbroad and at least 2 officers will continue to use it in retaliation for protected conduct, so the auditor can likely obtain injunctive relief and have the government permanently enjoined from enforcing this code without ever being cited or arrested for violating it.
Because that's in direct violation of the Constitution, and that's what I'm really here to do. I'm here to make sure. No. I plan on it, but your sergeant's making a big deal right now about me leaving, so I have to stand my ground to show her that I'm not going to leave because I have a right to do what I'm doing. And, I've offered her to enforce her code, and that's all I'm just going to peacefully exercise my rights here, sir. That's all. I'm going to stand up for what I believe in.
Ultimately, the officers left without issuing a citation or arresting the auditor, and the auditor went on his way. There is much more content in this video that we did not cover, and I would highly encourage everyone to watch it by clicking the link in the description below. Overall, the sergeant in this encounter gets an F. She not only knew nothing about the First Amendment and belittled the auditor's activity, but she didn't even know what public property was or even that a municipal code is a law. She was extremely aggressive from the beginning, showed no attempt to de-escalate the issue that she was causing, and acted like she knew everything and everyone else around her was wrong. Officers like her should never be on the force, as they are a big reason why there is such a divide between citizens and law enforcement. The auditor gets a C+. While he was probably within his rights to film the officers and could not be charged with violating the municipal ordinance at issue, his reasoning of why is much different than the actual reason. He appeared to not know about injunctive relief or the public forum doctrine, and had he stepped just a few feet to the side he would have unquestionably been well within his First Amendment rights the entire time. That being said, he was ultimately correct in his distinction between commercial and other speech, and in the fact that New York law has recognized a legal right to film. Additionally, he remained relatively calm and cordial throughout the interaction. I commend his efforts to de-escalate the situation, but I would highly encourage him to take a deeper look at the constitutional and legal rules associated with filming the police in the future.